My name is Palmer Johnson. I'm a family law attorney in Tulsa, Oklahoma, and today I'm going to be talking about the big question that I get all the time. Can I take all the money before we file for divorce? And the short answer is no, you cannot take all the money. Could there be scenarios where you have separate property that you've maintained before the marriage that you have very much kept as your separate property that you do not have to turn over to the other side? Yes, the answer to that question could be if it's separate property and it's not in any way turned into marital property, then potentially that will be yours. But depending on exactly how the account's held and things that you've done to it, you may have what was one separate property can sort of morph into marital property. There's a lot of factors that could affect how a piece of property or an asset is actually ultimately classified. If you have substantial separate property prior to getting married, potentially seeking some legal advice about a prenuptial agreement would really be wise, because you can use that as a tool to clearly state your intentions for certain property that is separate to remain that way and still provide for an upfront provision of some kind to your new spouse in the event that you dissolve your marriage. So if you just have a joint checking account with your spouse and there's $20,000 in it, can you take all $20,000 and close the account? No, absolutely not. But what if you're the breadwinner and you made most of that money? No, absolutely not. You're not going to be able to exclude the other side from access to all funds as a tactic to gain the upper hand in your divorce proceeding. If you want to remove funds before you file, I would say that in most instances you could take half the bank account, and that would be deemed a just and equitable distribution. But you probably would want to consult with an attorney before you made those decisions, because there could be different factors that would govern what would be just and reasonable and what would not. And the last thing you want to do is take a bunch of funds and then spend them potentially and be ordered to pay that back to the other side. I would be very cautious about things that I did to try to gain the upper hand or obtain more property at the exclusion of the other spouse right before you filed. There can be consequences for that, and certainly after the temporary injunction is in place, there are definitely consequences for that. But it's just simply not advisable, and the other side is going to figure it out. And so do yourself a favor and don't have to fight about things like that. Play by the rules, and but sometimes it's the other side that doesn't play by the rules, and you may need an attorney to help protect your rights and laying down the law and enforcing consequences on them for their actions. So you could find yourself on either side of this, but I would recommend not being the guilty party that has made the decision to unilaterally take assets to the exclusion of the other spouse.